Thank you very much, Your Honor. It is my intent that my remarks this afternoon be quite brief. I do not intend to relitigate the facts of this case, nor spend any substantial time looking at the law. The court is very familiar with the facts of this case, and the parties have fully briefed the court relevant to the sentencing factors. And we recognize that in any case, any sentencing that comes before the court is tasked with a difficult job. The court must craft a sentence that serves the interests of justice, a rather nebulous term. The court must take into consideration the victim impact, public interest, as well as the circumstances and the history of the defendant. And in this case, more than any other that likely any of us have ever been involved in, that task is exceedingly more difficult. In my remarks today, I just wish to briefly address each of those three considerations, starting with the public impact. As I believe we are all cognizant of, this case is at the epicenter of a cultural and political divide. We tried to keep a lot of that out of the courtroom during the trial and make this case about the facts. But we recognize what has happened as a result of this case. There are a great number of people who will view any sentence you pronounce as overly lenient and insufficient to satisfy justice. But there are an equal number of people who will view any sentence you pronounce as draconian or overbearing. Either way, some percentage of the public will view your sentence as a miscarriage of justice. The intensity of the public interest in this case cannot be understated. I trust that the volume of correspondence that each of us has received from the public at large is indicative of these very sentiments on both sides. As I was informed just yesterday, the Attorney General's office established a website, web submission, to accept community impact statements. Again, in my understanding is in a little over 2 weeks they received over 1,000 submissions. Again, on both sides. By my very best estimate, since my representation of Mr. Chauvin began last summer, I would estimate that I have received over 5,000 emails, over 1,000 voicemails, and hundreds of handwritten letters. Again, from both sides. And I expect that Your Honor has likewise been inundated with public comment and scrutiny. The impact that this case has had on this community is profound. It goes far beyond what happened on May 25th of last year. It has been at the forefront of our national consciousness, and it has weaved its way into nearly every facet of our lives, from the entertainment that we consume to the presidential politics, from protests to conspiracy theories. In the end, it is my sincere hope that when this proverbial dust settles, the community impact brings forth principled debate and civil public discourse, and ultimately leaves a positive effect on the city of Minneapolis, the state of Minnesota, and the United States. But nevertheless, while this court may consider the community impact, it is for these very same reasons that the court must turn to the foundational legal principles and remember that justice is blind. Law is built on reason and common sense, and it cannot be permitted to be assailed by public opinion. Turning to the second consideration, which is the victim impact, the death of George Floyd. The death of George Floyd was tragic. He is loved by his family members. He is loved by his friends, and his death is justifiably mourned by those whose lives he impacted. He is a son, a brother, a father, an uncle, and a friend to many. And as the court heard today, the impact and the loss of his life, simply just, it can't be simplified. And it will take time. Finally, Your Honor, the court must take into consideration, just like it has to take into consideration the aggravating factors, it needs to take into consideration the mitigating factors. And the mitigating factors as set forth by the sentencing guidelines really point to the TROG analysis, essentially, ultimately in this case. We're not going to spend a lot of time, again, arguing for a probationary sentence. That's briefed. But that being said, when we look at the TROG factors, who is Derek Chauvin? Derek Chauvin spent 19 years as a Minneapolis police officer. He loved being a police officer. I was contacted during the course of my representation and have had numerous conversations with his fellow police officers or fellow police officers that worked with Derek, some retired, some still active. And they told me that he was a solid police officer, that he did his job, that if somebody asked him to do a particular task, he never complained, he did it. One person told me that one of his sergeants told me that if I had asked him to dig a ditch for 8 hours, he would have picked up a shovel and he would have never complained for a second. He would have done his job. He was decorated as a police officer. Multiple life-saving awards. He was decorated for valor. He was proud to be a police officer because what he liked to do was help people. And as the statistics show, the vast majority of police work is helping people. He was proud to be a Minneapolis police officer. He served his country as the United States in the United States Army. And he too is a son, and a brother, and a father, and a friend. He too, his life, the life he's lived, he's not coming into this as a career criminal with 6 points, 5 points, 4 points. He's coming into this never having violated the law because he lived an honorable life and he attempted to live an honorable life. Derek Chauvin was not even scheduled to work on May 25th, 2020. He volunteered because there was short staffing at the time. I know from numerous conversations that I've had with Derek that his brain is littered with what ifs. What if I just had not agreed to go in that day? What if things had gone differently? What if I never responded to that call? What if, what if, what if? The truth of the matter is, and the end result is that we are here after a jury verdict, finding him guilty of these offenses. And the court's consideration should not only be focused on the aggravating factors, but the mitigating factors as well. The Minnesota Sentencing Guidelines Commission was established for a reason. And yes, the court in circumstances like these has discretion to go beyond and aggravate a sentence beyond the presumptive sentences established by the sentencing guidelines. But the sentencing guidelines don't differentiate between second-degree murders. Someone robs a liquor store, a police officer is involved in an incident, and a person dies in police custody. The law presumes, the legislature presumes, that the sentencing guidelines as established is a sufficient penalty for all of the second-degree murder categories or cases you would see. From 2019 back to 2010, a total of 90 people were sentenced for second-degree murder. Those sentences, those people, there were more than that, but people who had a 0 criminal history score, more than 90 people were sentenced. 67%, or 60 of those 90 people, received a guideline sentence of 150 months. So 2/3 of all people in this same position received a guideline sentence. 20% received an aggravated sentence, 18 of the 90, and 13%, or 12 individuals, were granted mitigated departures. So if the legislature and the intent of the sentencing guidelines is to eliminate sentencing disparity, the law should presume that the guideline sentence is what is appropriate in this case. Judge you may take into consideration at this point those aggravating factors, but you have to counterbalance them, which is the goal of the law, with the mitigating factors. I know that this has been an incredibly difficult case for the Floyd family to have to endure. The state of Minnesota, likewise, the prosecutors in this case have endured quite a bit, as has Mr. Chauvin's family. This is a case that has changed the world to some degree, and I hope it's positive. But it's my hope that the court follows the sentencing guidelines, applies the law in a reasoned manner, and imposes a just sentence.
Actually, Mr. Chauvin, would you join Mr. Nelson at the lectern? Mr. Chauvin, this is your opportunity if you wish to give any input to the court, and so I turn it over to you and your attorney.
Thank you, Your Honor. At this time, due to some additional legal matters at hand, I'm not able to give a full formal statement at this time. But very briefly, though, I do want to give my condolences to the Floyd family. There's going to be some other information in the future that would be of interest, and I hope things will give you some peace of mind. Thank you.